My name is Attorney Gabriel Carrera, and I advertise as the attorney that rides. You can find information about my law firm at attorneythatrides.com. And here I am, driving to work. It's Monday morning, and I wanted to talk to you about what happens if you get served. What's the next thing to do? If you get served, it's usually by a process server, and a process server has to either personally serve you, or they bring in papers, and just like in the TV shows, you've been served. The other way they can do it is at your residence. They can do what's called substitution of service. Let's say somebody's at your house. As long as they're 15 years old or older, they can serve them, and hopefully that person will give you the papers and say, hey, somebody dropped off these papers. That is good service for you. It has to be at your normal place of abode. There is a lot of case law where, let's say you move and the other side knows you're not really living there anymore. It's not your permanent place of abode. It can be overturned. But when you get served, you have 20 days by law to answer whatever it is, the divorce, the lawsuit, and a divorce is a lawsuit, a request for money, you owe a credit card money and they're suing you, or whatever it is. You ran over your neighbor's dog and he's suing you for pain and suffering and loss of whatever, he misses the dog. You got 20 days. Now, you can always come in and ask the court for an extension of time and just say, hey, you know what, I need more time to answer this. And from there, when you complete an answer, and you have to file an answer, you have to make sure that the original goes to the court, and always to the opposing counsel or whoever else is on the lawsuit. They get a copy. You have to mail them a copy. You just can't be sneaky about it and say, look, I'm going to send it to the court. I'm not going to send them. Screw them, You can't do that. Judges see right through that. You're not the first person to think about that. So, don't go that way. There's something called the mailbox rule. If you've been served, you get actually an additional 5 days, because they assume, you sent it in the mail. So you get an additional 5 days. Now, what happens if you're served and you're like, screw this? You just ignore it. That's not good. That's not good. Because what happens is then the opposing party, usually the attorney, is on the other side. He's counting the days. He's put it in his calendar. When that day comes up, boop, your name. Hey, so-and-so, check and see if he's filed an answer. They will. Then what they'll do is they'll file a motion for default with the clerk of the court. The clerk of the court will look at its system and say, well, this cat hasn't filed an answer, and they issue a default. So now there's a default issue. Doesn't mean they won the case hands down. The next thing that the individual needs to do, the opposing counsel, is set up a hearing with the judge. And that hearing is final judgment. And depending on what it is, if they owe money, they'll come in and say, look, here's the no. They'll just, a little quickie, 10 minutes before the judge, justify why the judge should rule in their favor. The judge will see if process service was correct, if he has jurisdiction, and he'll issue a final judgment. And from then on, if you owe money, they can go after you. They can come in and garnish your pay or do whatever. Usually, if it's a divorce, the judge will grant the divorce pretty quickly, unless there's children. Then they're like, whoa, wait a minute, let's see what's going on. Every case is different. Every judge is different. So here we're like, judges don't like, but if they do issue a default, and let's say your spouse goes and gets an attorney, and he has to vacate the final judgment, set aside the final judgment, like as if there was never a final hearing, then judges tend to put aside those final judgments and the defaults pretty liberally. They'll do that because there's a presumption that the matter should be heard on the merits.